Welcome to MedMark's webinar series. Today's presentation is titled To Repair or Not to Repair, the Shakespearean Question of 2021. I'm Kate Klaus, Senior Attorney in MedMark's Risk Management Department. On behalf of MedMark and today's presenter, Kasey Adams, thank you for joining us. Kasey Adams is an attorney with Butler Snow. She focuses her practice on pharmaceutical, medical device, and healthcare litigation. She has been a member of 2 trial teams in pharmaceutical product liability cases that resulted in defense verdicts, one of which was named one of CVN's top 10 defense verdicts of 2015. She currently serves as a key member of the deposition and national expert teams in the pelvic mesh litigation. She is also experienced in defending pharmaceutical and medical device manufacturers in consumer protection litigation brought by state attorneys general. Best Lawyers in America recognized her in its 2021 Ones to Watch for Healthcare Law and Products Liability litigation, and she was recognized as a 2019 Rising Star by the Mississippi Defense Lawyers Association. Kasey is active in the American Bar Association and currently serves as the co-chair of the Young Lawyers Subcommittee of the Mass Torts Committee. She has written multiple articles and practice points pieces for the ABA newsletter and website, and she recently organized and moderated a panel sponsored by the Young Lawyers Subcommittee at the ABA's Environmental and Energy, Mass Torts, and Product Liability Litigation Committee's joint CLE seminar. She is also active in the Defense Research Institute, Jackson Young Lawyers, Charles Clark American Inn of Court, Capital Area Bar Association, and the Mississippi Defense Lawyers Association, where she serves as the Young Lawyers Division Liaison. She obtained her BA summa cum laude in Business Administration from the University of Southern Mississippi and her JD summa cum laude from Mississippi College School of Law, where she was Associate Editor of the Mississippi College Law Review, Chair of the Moot Court Board, and a member of the National Order of Barristers. And with that, I am pleased to turn things over to Kasey.
Thank you for that kind introduction, Kate. Good afternoon, everyone, and thank you all so much for joining us. Like Kate mentioned, I'm an attorney for Butler Snow in our pharmaceutical and medical device group, and I'm really excited to talk to y'all today about a really interesting topic called right to repair. So before we get started, I want to try to make this as interactive as possible in this virtual space. So I want to start to just kind of get a sense of who all we have with us today. So if you have access to the hand raising button, do you mind clicking it to raise your hand if you are an attorney? All right, got a couple attorneys in the audience. You can put your hands down. What about anyone who works for a medical device company? Okay, you can put your hands down. Any consultants or insurance brokers or anyone else who works in the medical device sphere? Okay, great. Thank you. I just kind of wanted to get a sense of who all we have listening today. And I'd also be interested to know how many of you have even heard of right to repair. So one more hand raising thing and I'll let you all off the hook. But will you click to raise your hand if you have heard of the right to repair movement? So it looks like a couple of you have heard of this, and the rest of us, we will figure it out together. And for those of you who have heard of right to repair generally, you may be wondering what on earth this has to do with medical device manufacturers. And I promise we will get to that. But first, we're going to talk just generally about right to repair, what it means, the current and proposed legislation, some litigation surrounding the topic, and then we're going to talk specifically about the proposed legislation that relates directly to medical devices and what this could mean for this industry. So first, what does right to repair mean? Well, I'm sure many of you, like me, have dropped your iPhone, your Android, Google phone, whatever else you have, but you drop it on the ground, you hold your breath, lean down, pick it up to turn it over, and to your horror, see that your screen has shattered. I'm sure I'm not the only one this has happened to. I don't know about you, but I know when that's happened to me, I immediately start going through the options and, let's be honest, counting the dollar signs in my head of what I can do to get my phone fixed, or if I'm going to just need to buy a new phone. This concept ties into right to repair and this right to repair legislative movement. The focus for most of this legislation is on who can make repairs to electronic consumer products, or better yet, actually giving consumers the right to repair their own electronic devices, rather than having to rely on the manufacturer or some, authorized repair shop of the manufacturer, or, to be able to access the authorized proprietary parts to get something repaired. Interestingly, the European Union is actually in the process right now of enacting right to repair laws this year. There's a whole rollout where certain consumer goods are going to have to be independently repairable for 10 years after the date of purchase. And now organizations in the United States are pushing for similar reform here. Just this summer, New York Congressman Joe Morrell introduced some federal legislation to give consumers and small businesses the right to repair their own products. The idea is that it would require manufacturers to make diagnostic repair information, different parts, any tools needed for repairs, to make all of those readily available to those consumers. Currently, many electronics manufacturers require that any kind of repairs or any parts needed to complete a repair be made either by the original equipment manufacturer, which they refer to as OEM, or through one of their authorized vendors. So the goal of right to repair legislation is to stop that practice. And there's actually an organization called the Repair Organization. The Repair Organization is a coalition. It is promoting this kind of legislation at the federal level and at the state level. And they've published some model legislation for states to use in order to consider these kind of right to repair laws. And the model legislation primarily focuses on the digital equipment space, like we've been talking about, but it would require original equipment manufacturers to make the documentation, parts, tools, et cetera, available to the independent repair providers or to the individual owner. Now, the model legislation does include a limitation on divulging trade secrets. It provides that trade secrets are protected, and I have the language here on the slide for you. It says, except as necessary to provide documentation, parts, and tools on fair and reasonable terms. So what does this even mean? Who gets to decide what is fair and what is reasonable? This is precisely the issue and concern from a legal perspective with this kind of legislation. This broad language really just invites a lot of uncertainty and, of course, invites some potential litigation. Proponents of right to repair legislation say that this is all about creating a more competitive marketplace, cutting down on electronic waste, and minimizing the time it takes to get devices repaired. But product manufacturers, on the other hand, have some legitimate concerns about privacy and cybersecurity, particularly when it comes to electronic devices like phones. I mean, we all know how much data is stored in our phones and tablets and other electronic devices. Disabling certain security functions and providing access to hardware and other things that this model legislation would require so that individual consumers can repair their own devices, it could allow others to more easily gain access to stored data and other personal information. And I'm sure you can also imagine the copyright and intellectual property issues that could also arise. Now, the model legislation that this organization has put forth does not apply to motor vehicle manufacturers, but some states have actually done that separately, or at least tried to do that separately. Massachusetts actually succeeded at this in 2012, and it was kind of the first big right to repair movement in the United States. In 2012, Massachusetts passed the Motor Vehicle Owners' Right to Repair Act. Similarly to what we were talking about with the model legislation, but focused on automobile manufacturers specifically. So the act that Massachusetts passed requires automobile manufacturers to make available for purchase by owners of motor vehicles and by independent repair facilities to allow them to purchase the same diagnostic and repair information that manufacturers were making available to their dealers. And after this passed in Massachusetts, it actually led to automobile trade organizations signing a memorandum of understanding with all 50 states that was actually patterned on this Massachusetts law. This provided some certainty for automobile manufacturers because it would prevent them from potentially having to comply with different standards around the country if different states were to have their own legislation in this space. So that happened. There was a memorandum of understanding. Automobile manufacturers start providing this information. But then recently, Massachusetts actually expanded that law that was originally passed in 2012. And this has already led to some litigation. And so just to give a sample idea of what kind of litigation could come from these types of laws, this particular case was brought by the Alliance for Automotive Innovation, and it relates to an expansion of Massachusetts' 2012 right to repair law. The expansion was supposed to be enforced starting August 1st, actually, so this is really ongoing as we speak. It has been delayed for now, the start date has, but just a few months ago, there was actually a bench trial in this case. Judge Woodlock in the District of Massachusetts held the trial, and we anticipate a ruling any day now, actually. The crux of the case is that this new expansion of the law, it went beyond just giving independent repair shops access to the diagnostic and repair information. Instead, the new expansion would actually require automobile manufacturers to give independent repair shops access to a vehicle's telematics systems. The Alliance argued that complying with this law could actually put them at risk of violating federal safety standards. And they also raised concerns about how access to this kind of data from a vehicle, the telematics system data, how that could be exploited. And not to be dramatic, but when I was reading about this case and looking at the arguments that were made on both sides, all I could think about was the cars being hacked in the 8th Fast and Furious movie. So if any of you out there have seen that, you know what I'm talking about. And obviously, this is dramatized. I'm sure there's other depictions in television and in movies of a car's smart system being hacked. So obviously dramatic, but the concern is there. There is concern, and the auto manufacturers raised this, that this legislative expansion that would allow access to the telematics systems could really put the safety of the cars in jeopardy, because telematics systems are very intertwined with the safety features of cars. And I think we can all agree that cars are essentially computers on wheels these days, at least the newer models are. So be on the lookout for a ruling. Judge Woodlock actually said to expect it by the end of August. I checked this morning and a decision had not come out that I had seen, but if you're interested, keep an eye out on it because there could be further developments from this case. So I've got the case name there for you as well in case you're interested. But this just gives you just a preview of the kind of legal concerns that can come from this kind of litigation, particularly as there's attempts to broaden it and then make it cover more and more proprietary information. And the implications of the right to repair legislation are really far-reaching for a variety of industries. In fact, as of earlier this year, there was about 27 states actually that had introduced or carried over some kind of right to repair legislation in their states. Some of them focused, on consumer devices, the electronics, cell phones, things like that we talked about. Others on agricultural equipment, like tractors, plows, other farming devices, things of that nature. Other states actually proposed even broader legislation that would cover all non-car devices. And then some of the proposed legislation did specifically exclude medical devices, but other states did not. Their language was very broad. and some specifically focused on medical devices. And the potential concerns of this kind of litigation, this right to repair concept, is particularly concerning where medical devices is the topic. Because now we're not just talking about your cell phone or your tablet or even a car. Now we're talking about diagnostic and life-saving medical equipment. And I don't know about you, but I would personally be concerned about being, in an MRI machine or hooked up to dialysis or any kind of device that was serviced by just anyone. Y'all may be over my screen references, but I can't help myself. But for my fellow Homeland fans out there, spoiler alert, but there's actually someone on the show that gets murdered by someone hacking into a pacemaker. Again, a little dramatic, I know, but technology and servicing medical devices really are intertwined. Another example, my dad is very handy. I mean, I would absolutely trust him to watch some YouTube videos and figure out how to replace my shattered iPhone screen. If I purchased a new one to install myself, absolutely handing it over to my dad. And remember, the model right to repair legislation really started for these kinds of issues and those kinds of electronic devices. But despite how handy my dad is and what a quick learner he is, I would not want him repairing or replacing any parts on an insulin pump or patch or some other medical device. These are obviously extreme examples because even with the proposed legislation, your regular Joe Blow is not going to be tinkering with your pacemaker, but you get the point. Just to think about just kind of big picture some of the impacts. And I mentioned, a lot of states have been advocating for this kind of litigation, but particularly in the medical device sphere, the current environment, because of the COVID-19 pandemic, has really brought the issue more to the forefront in several states and on the national level in this last year. The pandemic has obviously been especially challenging and taxing on our medical system in so many ways. One issue that was often highlighted was inadequate supplies of medical equipment in many hospitals, particularly rural hospitals. And this included everything from personal protective equipment to access to ventilators. And we're starting to see this again, particularly with ventilators during this latest surge from the Delta variant. So citing these kinds of issues, Senator Ron Wyden of Oregon and Congresswoman Yvette Clarke of New York introduced the Critical Medical Infrastructure Right to Repair Act of 2020 last year. That is quite a mouthful. But this legislation ultimately did not pass, but the purported intent was to remove barriers to fixing medical equipment during the COVID-19 pandemic. Specifically, it would require manufacturers to provide, on fair and reasonable terms, there's that language again, access to information and tools that can be used to diagnose, maintain, or repair medical equipment. The law, as proposed, would also allow owners, lessees, servicers of medical equipment to be able to repair or maintain those critical medical infrastructures. Now, some of you may not be as nerdy as me about these kinds of things, but I really am fascinated by things like this and really thought it could be helpful to walk through the actual language of this proposed bill, really just to fully understand its potential impact on the medical device industry and understand some of the arguments on both sides. So as you can see here on the left side of the screen, the listed purpose of the bill is to address circumvention of copyright protection systems when it comes to maintaining or repairing the medical devices. And the definitions on the right that I have circled, it defines critical medical infrastructure contract as a contract relating to the purchase, leasing, licensing, repair, or maintenance, including periodic maintenance of critical medical infrastructure. Then when you go farther down into more of the meat of the bill, you see under permissible circumvention, it says it is not a violation of that subsection, meaning that the bill would make it not a violation of copyright laws for a covered healthcare provider to circumvent a technological measure that controls access to protected work if the purpose is to repair or maintain critical medical infrastructure. And then there are some limitations that are included. It indicates that healthcare providers are not exempt from complying with any other applicable laws or regulations, things like that. And then it also gets into some patent issues. And it's saying that a healthcare provider will not be infringing on a patent to fabricate a part for the repair or maintenance of the critical medical infrastructure. And then on the right is where it really gets into the specific requirements for manufacturers, where manufacturers are provided, and you see there the on fair and reasonable terms language, but it actually establishes a duty to provide the information needed to diagnose problems, service, maintain, repair equipment. And it goes on to also include a duty to make the necessary tools available. And it says if you can't make the tools available, it actually requires you to provide information to aftermarket tool companies to make your tools and provide the necessary equipment. Then you see there is language regarding the protection of trade secrets. The intent is to keep trade secrets from being disclosed publicly, but the caveat is that the information cannot be withheld if the information is provided to authorized dealers or service providers. And finally, on the right, you see that the enforcement of the bill, the party charged with that would actually enforce these laws, if it were passed, would be the FTC, or the Federal Trade Commission. So as you're reviewing this language, you know, I know for me at least, a lot of questions about these provisions and the potential enforcement of them came to mind. And there were several states that sought to implement very similar language related specifically to medical devices, like this federal one we just looked at in the last legislative session. Texas had one, California had one, Hawaii had one. And now, admittedly, all of the proposed legislation related to medical devices were tied to the pandemic and equipment necessary as a result of the pandemic. But the reach could end up being broader if support for the legislation grows. So it's important to be aware of, and important to understand exactly what kind of requirements would be put on manufacturers of medical devices if laws like this were to pass. Now, proponents of the legislation cite two instances, particularly during the pandemic, where hospital equipment was down for hours, weeks, or even longer until hospitals or the biomedical technicians at hospitals could get a representative or an authorized technician from the manufacturer on site to be able to service the equipment. And people that are pushing for these laws are claiming that patients are suffering from these delays, and that allowing the hospitals and their technicians or other independent service providers access to this information to be able to make the repairs they need would be better for patients. The argument is that any barrier should be removed to allow the on-staff hospitalists to be able to service the information and make sure that they have whatever information medical device manufacturer and their authorized technicians have about certain equipment. And when you look at the logic of this argument just squarely on its face, particularly in light of the pandemic, it makes sense from a practical standpoint, right? But the concern, and why I wanted to point out the different language in the bill, is that there are just so many gray areas and a lot of just potential hidden dangers here. As you can tell, I think, from the different language that I pointed out. Now, obviously, opponents of this kind of legislation against the right to repair legislation, particularly regarding medical devices, cite primarily to safety concerns. The framework that's currently in place for manufacturers of medical devices and the repair and service of those medical devices, it's highly regulated. The current framework ensures safe and proper servicing of highly complicated medical equipment, which I think everyone can agree is a good thing. And this proposed legislation would force manufacturers in many instances to actually give software and service information for their devices to these independent servicing organizations. The question then is, what happens with that information? Would the independent organizations, would the biomeds at the hospitals, would they be required to properly source and test parts for replacement? Would they be able to put just any replacement part into a manufacturer's medical product? You saw the language that I showed you from the proposed federal bill, about fabricating parts and talking about aftermarket tool companies. And so the question then is, if legislation like this were to pass, would those groups be held to the same safety and training, regulations and standards that the manufacturers are subject to? The list goes on, but ultimately, medical devices that are inadequately serviced or not serviced, up to certain standards could really have severe safety implications for patients. And that's the biggest way these legislative attempts really could impact the medical device industry. Manufacturers go to great lengths to ensure the safety and efficacy of their devices. And all of this is in conjunction with the FDA and with FDA regulations. So this kind of legislation could not only force manufacturers to hand over confidential training materials and service tools and things like that, but to also have to hand over, the blueprint to parts, the blueprint to replacement parts to these third-party servicing businesses that are just not regulated in the same way that a device manufacturer is. Now, I do want to take a second to address the regulation aspect of it, because there is a hot topic of debate surrounding these proposed laws when it comes to regulation in general. And admittedly, there are a lot of lobbying efforts on, and lobbying dollars on both sides of the debate here. So it's important to try to drill down and cut through the noise. But we all know that medical device manufacturers are regulated by the FDA. So what about these independent service providers that would get access to this service information under this kind of legislation, if it went into law? Obviously, these independent service providers and these, non-authorized repair technicians or hospital biomeds, these entities are not regulated as manufacturers under the FDA because they don't manufacture the devices. But those who are in favor of right to repair legislation, their big argument on this side is that these independent service organizations and in-house repair folks are still required to follow all state and federal laws, and regulations. And admittedly, the proposed legislation language that I showed you did include, a provision that said, hospitals weren't exempt essentially from following state and local rules. But the independent service organizations are accredited by Centers for Medicare and Medicaid Services, not the FDA. So even though on their face they're still required to follow laws and regulations, it's different accreditation requirements. And that's why those opposed to the right to repair laws argue that these are much different standards, and they set forth very different requirements than those put on the device manufacturers. And not only does this potentially put safety at risk, but the quality and the efficacy of these devices could also be at risk. So the quality concerns is something else that you have to think about when it comes to this kind of legislation. And frankly, particularly when it comes to a medical device, whether it's a life-saving or a diagnostic one, a device that's not working properly, if it's not efficacious because it was not properly serviced or because a replacement part was improperly, included, this is also a safety issue. If a device isn't working when it's a medical device, efficacy leads to safety. So this all ties in together. And of course, litigation, as evidenced by the case in Massachusetts that we talked about earlier, there's a lot of legal concerns that can and most certainly would arise if right to repair legislation, particularly related to medical devices, were to pass. And I'm sure you can think of several questions and examples just from what we've talked about so far. I mean, for one, what about liability? Is a manufacturer going to be completely shielded from liability under these kinds of laws? If there's a medical device and it malfunctions after it was repaired or had a part replaced by someone other than someone authorized by the medical device manufacturer, is the manufacturer shielded from liability? Would liability then fall on the repair person? I think there's an argument that it could be an absolute shield for the manufacturer because, the device was not as it left their hands. But you also have to consider whether it matters to the liability question what information the in-house technicians or these independent service providers were granted access to. So the proposed bills set forth to make sure the independent service providers have all the same information available to the manufacturer. So if an independent service provider or the repair technician, does things exactly laid out in the blueprint from the manufacturer, then can they come back and say, nope, actually this is on the manufacturer? So would that matter or not? Where does or should liability stop when it comes to devices that have an issue or purportedly cause someone harm whenever there was that intermediary in between as a result of this right to repair legislation? Another, important question that keeps coming to my mind, and I've pointed it out several times now, is this fair and reasonable language. That language is in the model legislation. It was in the proposed medical device litigation. It's in all the litigation about this right to repair that you'll see. But what's the gray area there, in terms of what is fair, what is reasonable, what has to be provided, what materials does a manufacturer have to provide access to? And then you also have to think about how disputes will be resolved in terms of interpreting what's fair and what's reasonable. Who's going to govern the disputes of, when an independent repair technician says, you haven't given me everything that's fair and reasonable in order for me to repair this part. And so, that's another gray area. Another question to raise is, who pays for the information? Who pays for the tools? Who pays for the passing on of this information from the medical device manufacturers to these, biomeds or independent service providers if these laws were passed? And then obviously we have the issue of, confidential trade secrets, the protected information, patent issues, reporting requirements, particularly in terms of reporting requirements to the FDA. The list goes on and on of the holes that you can find in these proposed bills, and a lot of questions that to date have not been able to be answered in terms of how the legislation would actually apply. And these kinds of unanswered questions are largely cited as to why the bills proposed to date did not pass last year. So I also included cybersecurity on here as a potential impact, because that's an ongoing threat. Pandemic or not, cybersecurity is a very important issue right now. There have been a lot of reports of cyber threats to hospitals being on the rise. In a lot of instances, our hospital systems are very highly integrated with technology now. So, anytime you open up access to certain vulnerable equipment in a hospital, that could end up putting the hospital or the patients and the device manufacturers, everyone who's involved, at risk. So that's also something to keep in mind when thinking about this topic as well. And then just generally thinking about the takeaways from this right to repair concept. First, I really think it's just important for all of us to be aware that this legislation is out there, be aware that there are attempts to make it apply to the medical device industry, that there are a lot of organizations out there that are pushing for this kind of legislation. And it's going to be important to stay up to date, know what's going on, pay attention to this bill that's been introduced federally, although that one does not apply. The one I highlighted earlier that just got introduced does not implicate medical devices. Pay attention to it, see what happens, and I wouldn't be surprised if we see another bill specific to medical devices be introduced as well. But keep up with bills like this, particularly in states that you're engaged in business with. Know what, if there's legislation like this that's being presented, and keep an eye on it. And if there is a bill introduced related to medical devices in your state or on the national level, make sure you read it. Look through the language of the bill. Try to understand how the proposed language would impact you and your industry specifically. And that gives you the opportunity, if there are concerns in the language, if you, are afraid there's a lot of gray areas, like some of the ones that we've pointed out in our conversation today, that gives you an opportunity to, work with your teams to advocate, to spread awareness about the potential shortcomings of the bill or the gray areas or these, unanswered questions. So, raise those questions, ask them, ask the questions that relate to safety assurances, ask the questions that relate to efficacy assurances, ask the questions about reporting requirements, ask the questions about liability and how, what the impact of legislation like this would and could be in your community and in your industry. And, engaging your community here is important. For those of you that work for medical device companies, your brand is important. And obviously the well-being of patients is your top priority. So, make sure that does not get lost in all of this back and forth, particularly when the proponents of this legislation really try to make it a competition-driven issue or try to make it a monopolistic one. Keep the focus on the customers that you serve, how you can continuously serve them better, and just, keep doing what you're doing and providing, excellent service to your communities. So that's just kind of a broad level overview of this litigation. There's obviously a lot to talk about in it, and so I tried to just kind of hit some of the highlights of the general legislation and boil down to medical devices. But happy to answer any questions or have any dialogue, but it's been a very interesting topic to me, and one that I'm particularly keeping an eye out on as we move forward. So any questions?
Thank you very much, Kasey. We do have a few questions for you from our listeners. First, with regard to the proposed federal legislation, does it provide liability protection for manufacturers of devices repaired under the right to repair law?
No, that is a great question, and it does not. I pointed out some of the language on the limitations, but and as you saw, what I did show, really the only limitations with respect to manufacturers is about protecting their trade secret information. But really the protections of the bill that are written into it as proposed were really focused more on protecting hospitals and protecting healthcare entities from any copyright or patent infringements, things like that. And that's a big concern to me of this kind of legislation, is that there's not that liability protection. So great question.
Next question, do you anticipate that more states may attempt to enact medical device right to repair legislation in upcoming legislative sessions?
I do. I definitely think that we're going to see that. We'll see if any are successful. The ones, in the last legislative session were not because of these, gray areas and unanswered questions. But there were several attempts last year, and some of them, I believe it was California actually came pretty close to succeeding, and particularly with this current surge of the pandemic and the fact that it continues to surge in certain locations. I definitely think it's going to be a topic on people's minds, and that those promoting this kind of legislation are going to use the current situation to get this legislation presented again in some states.
We have one last question. If a medical device manufacturer is opposed to right to repair legislation, how can they voice that opposition without seeming insensitive to the current needs of medical facilities and the communities they serve?
Yeah, this is obviously important because, at the end of the day, patient care is obviously the priority. So I think it's important to make it very clear that the opposition is not about patient care. The opposition is about the far-reaching concerns of what this legislation could do, and the fact that the legislation could actually lead to more dangers and more safety concerns for patients. And I think one important part of it is just how we show good faith in how we're attempting to meet the needs of our communities. For instance, as medical device companies, we could, have more licensed representatives available. We could provide, voluntarily some limited access to non-proprietary information in emergency situations, things like that, to show that the focus is on safety, and, really making it clear that this is not about wanting to maintain control for competitive purposes, but that it's truly about the safety of patients. No one wants to rely on, some kind of life-saving device that's been serviced or repaired in a way that's not regulated according to certain high standards. So I think it's a delicate conversation, a sensitive conversation, but one that we should be able to have, head on.
Thank you very much for your time today. This is a timely and important topic, and I know your presentation will be valuable to our audience.
Thank you all so much for having me. My contact information is on the screen if anyone wants to talk offline or reach out about this topic at another time.
Thank you for joining us. This concludes today's presentation.